Okay. Good evening, everyone, and a warm welcome. Today is a very different and unconventional topic. We have with us Advocate Meera Sanzgiri. She will be explaining living wills. I will not go into deep because even I'm not aware much about what a living will is. We know what a will is, but a living will is a very different thing. So I would prefer that she explains you all what it is exactly. And to introduce the speaker, I would like to call C.A. Bhavesh, our coordinator for today, core group member, to introduce her.
Thanks, Purvi, for giving me an opportunity to introduce the speaker. Advocate Meera Sanzgiri is an advocate practicing in the area of family laws since past 3 decades. Meera is a notary, public notary, certified mediator, child independent lawyer, post and postcode trainer. She has been kept a keynote speaker at the professional forum over a past decade, speaking on divorce, maintenance, and domestic violence. She has lately been speaking on living wills. Meera has a co-author of a book and also an advisor to the various firms regarding this living wills. Thank you. And I I invite Mahesh Bagaria ji and Abhijit ji to give the moment to Madam. Yeah, she is a better half of Abhijit ji. अरे
अच्छा लगे आपके हाथ से
स्लॉट दीजिए चलिए अभी
just play your
yeah, understand it.
Yeah.
Space.
wanted to move it this way. I don't know what to do actually. This is too. It's okay. It's okay. Yeah, just share your screen.
Good afternoon, friends. And I know this is really hot, but a very good topic is going to keep you entertained. So I'm sure everybody's heard about wills. So wills has been everybody's aware of wills, where it is a legal document where you note down and set down everything that you want to distribute regarding your properties and assets among your beneficiaries. Will has an executor. Will has to be made by a person who is mentally and physically fit. So you need a doctor's certificate to make a will also. You need 2 witnesses who have to sign in whose presence the person signs. Will can be notarized, it can be registered, but there is no compulsion. There are no fixed format for a will. Anybody can write it on a piece of paper, leave it, and that will is executed. So now what is living will? Living will is a new concept. So living will is that a person makes a will who is physically, mentally sound and who has a advance directive is written there regarding what should be done if I'm unconscious or not in my senses, to give a directive to the hospital for the medical directives. That is, for example, a person is in coma. He's unable to give his consent. as to what should be done, what medical help should be given to me, whether I should be kept on a ventilator, whether tube should be given to me, whether I should be treated like a vegetable. All those treatments, whether you want the treatment or not, you can write it down and state your wish. So living will is stating your wish on paper, and it becomes like a directive to the hospital so that they do not treat you further. Now, this sounds easy, but it's not. In the sense, this is also called as euthanasia. That is mercy killing. Yeah. So mercy killing, there are two ways: active euthanasia and passive euthanasia. So active is what you inject from, you give an external force. You inject something, maybe an injection or some medicines, as a result of which you can have instant death. And what is passive is stopping the treatment. Like you're on a ventilator and you're being fed on external forces. You are alive because of some external force, and you do not want that treatment has to be stopped. For the treatment to stop, the doctors can't do it on their own. It has to be with the living will permission. That is the person who wants it to be done. That's a living. He has to make a living will for that. It is the right to die with dignity. The principle is the right to live with dignity and right to die with dignity. So Article 21 very clearly talks about right to live, and right to live and right to die is also, it's part of right to live. So now there were a lot of discussions where doctors said that this could be against our professional ethics, because doctors' ethics are that we will treat the patient till his last breath. But this is not so. So the Supreme Court was always thinking about it. They have considered whether it should not be considered as suicide, it should not be considered as a murder, it should not be considered as against your professional ethics. So all that parts were considered by Supreme Court. When was this introduced and when did this start? So this was because of a very, very landmark judgment and the case which everybody is aware is regarding Aruna Shanbag's matter, where you all are aware that Aruna Shanbag had a very bad, she was raped and she was a vegetable for 42 years. And she was in KM Hospital. KM Hospital people took care of her without any remuneration. And it was a very sad thing. So there was a journalist who took a chance, and she, in 2009, she went and applied to the Supreme Court stating that this is a fit case for mercy killing. So Supreme Court was convinced. But then Supreme Court thought about it. They said, it should not become like a regular thing. So people will start taking advantage of it. That's the reason Supreme Court thought about it, and they set up certain guidelines as to who can file this case. So the guideline was that who can file it? Firstly, the parents of the patient can file it if the patient has not made a living will, because that time there was no concept of living will. So they said either a parent could do it, because parents are the only people who love a child unconditionally. They cannot do something against the child's wish or for the child. So it's the parents. Second, it was the spouse. Third, relatives. And fourth is a near friend. Now, this journalist was neither a family, neither a spouse, parents, nor friend. So who was the friend that they considered? They considered KM Hospital as a friend. So if KM Hospital would have filed it, there was a chance that could be passive euthanasia could have been given in 2009. But it didn't happen. By the time the judgment came forward in 2011, they accepted the fact that yes, this is a fit, this thing has to be thought about. They created a body, they had discussions. Finally, in 2018, the guidelines were set up by Supreme Court. Guidelines with lot of thorough discussions with eminent people from different fields, law, medical. Everybody together thought about it. And they came to a conclusion that yes, this is a need of the time. We need to think about passive euthanasia and some steps have to be taken. So in 2018, Supreme Court set up certain guidelines. Now, what were those guidelines? The guidelines were that the person who is making a will, living will, should be mentally and physically absolutely fit. That is, she or he should understand before making a will. He should understand that, yes, I do not want to live a life like a vegetable. I want to die peacefully. If there is no chance that I will revert back, if I'm unable to come, I do not want to suffer. I would want to be left the way I am, or my support, my life support should be stopped. So the person should be aware is the first thing. Secondly, the living will has to be made in presence of 2 witnesses. And the third one, it should be countersigned by a judicial magistrate court, first class judicial magistrate. That was in 2008. Thereafter, this living will is ready. The living will also should have an executor who will have the knowledge that this person has made a will. Now something happens to this person, he's in the hospital and the physician is made aware by the executor that, well, the living will is ready, this person had a living will. Then the hospital makes a medical team of 3 doctors. All 3 doctors will be seniors, that is more than 20 years of practice. Plus, they should be from different fields. That is, not all doctors will be only a cardiologist. They should be from varied field. 3 of them should give an opinion. That's the primary body. After they give an opinion, the living will goes to a district court. There again, the district collector again forms a secondary body of 3 doctors, different doctors. They will check the patient. They will give their opinion. And thereafter, the living will is sent to the judicial magistrate who had signed as a countersign. The magistrate himself comes to the hospital, checks and gives an opinion. And finally, the passive euthanasia. Yeah, it is removed. So this was the whole process. Now what happened was, this was extremely cumbersome because people, practically it was becoming difficult. We did not have the time limit, didn't know how the things are functioning. So though the court were aware, though the Supreme Court was helping out, they knew the problems, but they couldn't give the procedure. 2023, that is just now. In Feb 2023, after a lot of discussions, lot of appeals to the Supreme Courts and High Courts, with so many cases and references, they have now come up with new guidelines, which are much easier, simplified. I'll tell you what. What they have changed is that, again, the same part is that both the patient should be aware. The awareness is fine. They should be mentally and physically aware what they are getting into. It should be signed by two witnesses, and there is no requirement of a judicial magistrate. It can be notarized or it can be done through a gazetted officer. So it can be notarized. Once the living will is ready, thereafter, the living will have an executor as the first thing. If situation arises where the patient is in the hospital and it is impossible for him to revive back, the living will is given to the physician. The physician who is treating the patient, he will form a primary group is made of 3 doctors. The 3 doctors, that is the hospital, the 3 doctors will check the patient, will give a report. There is no need of 20 years of experience. Only 5 years of experience is good enough for those doctors to be on the panel. So they have reduced that 20 years to 5 years of experience. Thereafter, the living will is sent to the district officer, where again there is a panel of 3 doctors. out of which one is a chief medical officer. It's from the same hospital, but at different doctors. So again, so your living will is examined by 6 doctors. All of them will check it up. And the second board, they will check, they will give a report. Earlier in 2018, there were no time limit. And you know how India works. So now they kept it to 48 hours. So the first 3 doctors after checking within 2 days, it is the next 3 doctors, and the report is given. So it's 48 hours that the result, I mean, you get your whatever, the decision is told to you. Thereafter, there is no need of calling the judicial magistrate to meet the patient. Intimation is good enough. And if the doctors give an intimation or they give an opinion that we don't think this is a fit case for mercy killing, then you can appeal to High Court, and High Court will again appoint 3 doctors, a separate set, and they can give an whatever their verdict. So they made it quite easier, faster, and they have reduced the time limit. They have reduced the strain that the people have, the patient and also his relatives. So these are the facts. Now, coming to what is it that everybody has a fear, many of my clients have approached me for, they have their own questionnaires, they say, madam, is it so that if I make a living will I not be treated? Will my children just put me in the hospital and I will just, they'll say, it's okay, abhi koi karo mat, treatment ki zarurat nahi hai. So will that happen? So it's not so. Secondly, it is not even an urgent thing. It's not an urgent thing. You can decide when to go ahead only when you have made up your mind. Even I'm talking about your own children and anybody. But you know the wish of your parents, or for that matter, anybody who's made a will, that you do not want the person to suffer. It's only going to be used at right time. So it's not a thing that your treatment is not going to be given. It's the difference is the treatment is going to be stopped. That's the only difference. Now, there are many countries who are in favor of it, and there are many countries who are not in favor of it. For example, UK, they do consider this as manslaughter. They do not agree to it. But in USA, there are certain places they admit it. They agree to it. So now if you make a living will here, there are the other question that comes up is, what if you make a living will here? Will it be you go to UK? I mean, I made a living will here and I've traveled with my son to US. Now will this living will be useful there? So that depends on that particular place's laws. You cannot go to a place where living wills are not going to be accepted. That will not be. So you cannot say that India mein to chalta hai. I'm in Indian, so वैसा नहीं होगा. जहां आप रह रहे हो वहां का लो. So that is how it is. So living wills, actually, this is an awareness thing where I normally have my sessions for awareness. People are not aware of living wills. It is not something that only senior citizens have to do it. In fact, living wills should be done by everybody, because you never know. It could be due to accidents. COVID has taught us a lot of things. So you never know when we may reach a stage where our life is stuck with, life supports. But we do not want to suffer. We do not want to see our loved ones being suffering. So that is a right stand that the Supreme Court has taken. And that is how Supreme Court has evolved. Now there will be issues. Now it is like 2023. In Feb, they have just started this thing. So the law is going to evolve. There are going to be pros and cons, and we are going to see changes. So 2018 to 2023, there have been a lot of changes. There have been a lot of case studies, as a result of which the Supreme Court was of a view of changing the laws. So also there will be more questions. There will be new case studies, as a result of which there will be some amendments also for this. I personally, if my opinion, when I went through this amendment, the first thing that struck me was 20 years of experienced doctors has come down to suddenly 5 years, which was too short. So that was my personal view. I thought that was too short. It could have been maybe 10 or 11. Yeah. So this is our views. So there are professionals, there are people who will be giving their views. And I think views matters. So firstly, we have to know what are laws. We have to know what are our rights. We have to know, and we are the people who can change laws. So we must make use of whatever knowledge we have. As professionals, I think you all are well aware of it. But that is how it is. So any questions that you would want to interact? I mean, anything that we would discuss? Yeah.
It appears to be a,
Yes,
the legal aspect is there. At the same time, medical aspect is very much there.
it is.
In 3 doctors, they are going to deny that case to find out whether it's
Fascinating.
so. Suppose it happens like this, that the person is fed up with his life and he is also given, maybe relationship with the close ones, near and dear ones is not so much good. Now, the medical doctors are going to independently see, independent of what has happened in their family, whether the case is fit enough medically to get euthanasia, or there's a difference of opinion comes.
No.
What would happen if the doctors feel that no, they should continue? Because see, here the patient himself does not have the disposable income at his disposal to spend money, or maybe the children are not interested. Somebody is in US, somebody is in.
Absolutely.
So this appears to be a little complicated here.
So, yeah, because see why this came into field, because same thing. Only because a person is alive because of this life support,
Correct.
the hospital is only life support.
No, but madam, there is a difference. Like suppose you have given in writing
Yeah.
that the patient has to be put on a ventilator.
Hmm.
Then you cannot ask the doctors to put their ventilator off.
That is precisely
So
where
there the
no.
and these will be
No. This is the difference is, so what you're saying is whether if the patient has written that I should not be put on ventilator, is that what you're saying? I should,
it's a clear.
no.
He's saying that the patient has said I should be put on ventilator.
No.
The
See,
patient
here
is
problem
saying-
is not on a ventilator, then of course the case is very,
No.
because
no,
then in
no.
that case the doctors will not put him on the ventilator.
No, that is the difference. That's the difference. So this is what you're talking is, yes, these are advanced directives. Advanced directives is making a list of what I should be treated for, what steps should be taken and how I should be treated is this directives. So there are 2 ways. One is advanced directives, meaning giving to the hospital, stating that I should not be I should not be put on ventilator, or I should not be given blood transfusion. See, there are even religious purposes. There are certain views of people that I should not be given somebody else's blood. There are people who think like that. So they write it down. These are advanced directives written and given to that is a living will. That the living will is part of advanced directives. So this is a different thing. But what we are talking now is stopping the treatment. If he's on a ventilator, because what happens is when you're saying he should not be put on a ventilator, see, maybe a person to be put on ventilator comes under the ambit of professional ethics of a doctor.
Correct.
Now you're saying he cannot afford it and he should not be put. That is a decision of the family, which is fine. That is I'm saying, that is easy. Now we cannot afford it, doctor. He's saying, okay, we cannot. If you're taking the patient, doctors will say, this is not my responsibility. You're taking it on your own.
You
You're
sign it and take the patient.
you take. That is a different thing. The question arises where he's put on a ventilator and now you're saying that the bill is increasing and now I cannot afford. Then the doctor cannot say that now doctor abhi band karo. Nahi hoga.
Yeah, murder.
That will be murder unless there is a living will. Or else if there is no living will, let's say there is no living will and you put it because they're not that everybody is aware, not that everybody has made a living will. Then what happens? So you're on the ventilator, you're being given fed through your medicines, treatments, life support. And then you decide that I don't want to go ahead with it. What do? You have to approach the High Court, tell them that this is a problem. This is what I need to do. You can approach. Why? Because you either are a parent or you are spouse or your family or your dear friend. So if you fall in these four categories, you can still go to High Court and apply and convince the court. And if the court is convinced, then you're entitled. So now, as I said, 2023, they have given a time limit of 48 hours.
Even for the food.
Yes. So that 48 hours is a time limit, whereas in 2018, there was no time limit. So then that went on and on. So it was very, very fluid. They didn't know how to take it out.
So 48 hours. The writ would be filed. What it is?
It's a writ. Yeah. Which you file in High Court.
Yeah.
Yes. But then here, what I'm talking of 48 hours pertaining to when they make a living will, and when the board is primary board is made, those people also have to give a report within 48 hours.
What cases 48?
48 hours, yeah. So that's the fastest that they have done. Yes. If you do not have a living will, then those three categories can apply to the High Court. Yes.
So what is the trigger point for execution of this will? Means patient has to be unconscious or in coma, or when the patient is at his senses that time?
No. When the patient is unable to communicate his wish, that is either he could be in coma, he could not be in his senses, he's mentally brain dead, there is no chance of he reviving back. Main trigger point is that there is no ways that he can be revived back. He's having.
No, means he has to be unconscious. The patient has
Yes.
to be unconscious, or he can be conscious but not in good state of mind.
No, generally it is totally unconscious. Yeah. So because he is unable to communicate in any which way. See, if he has little consciousness or something, maybe there are chances that he might revamp. Generally, what is considered for passive euthanasia has to be totally a irreversible thing.
In this case, son or otherwise to carry on with the treatment, and the doctors have told him categorically that considering the age and all other factors, even if spending of money is not going to help you much.
Right.
So that time, now suppose there is no living will, but now the relatives will have to go to High Court.
Yes.
Because
With all the
in my
doctors.
case- In my case, some 5, 6, 7 years back, I had two unmarried aunts of mine, totally dependent on me. Both were about 85, and we had a similar situation. Where we wrote on the form itself in the hospital, and the treatment was slowed down. The main treatment was not given, so that creates a lot of complications for them. And then but it's very difficult because you keep on pumping money, and the patient is not going to come back home. So during those times, the only was given that I have such a person. Now I have to go to High Court.
Because what was happening all this while is there were hospitals, there were doctors who were actually stopping the treatment, or they were cooperating with the people. They say it's okay, mat karo doctor. Hospitals will think that we are unnecessarily treating a patient. How many of them, like KM Hospital, like Aruna Shanbag, they took care of her for 49 years. That was because she was there. But then they took a statistics of how many of them really take care.
But then that case was different.
That
Because
was
the
a
doctors
totally
and nurses,
different.
the nurses.
That's what I'm saying. That's precisely what I'm
She was
saying.
alive. And her relatives were not there. Or maybe
No,
they were not.
What I'm trying to say is, how many of them really want to do it? Like her,
No, that was an extreme.
extreme case. So that's why normally people would want to get over it. Money wise, remuneration, health, financially also, mentally also, they are very.
Basically, on the vegetarian state, when
Yes.
it becomes a vegetarian state, then
Yes.
life support.
Has to be stopped. Plus, you cannot give a guarantee that once the life support is stopped, the person dies immediately. No, then that becomes a natural death. That becomes a natural death. But 99% of the time, the thing is that once you stop the treatment, the person is not going to, because she is alive or he is alive only because of life support. So that is the idea of a living will.
In case of
Yes.
Then is there any difference in the will?
No, because you cannot, in case it happens, when the living will before it, I mean, before the patient, you're saying?
Yeah, before the patient dies.
Yeah, you can always add a new witness.
But
You'll have to make it again. No, no.
We have to go.
Yeah,
on
because
all
then
the
you need to have it, you need to make it again if you are alive and if everything is fine, or else whatever is there. I mean, you cannot, you see, if it happens at the same time, probability is less, right? That everybody dies at the same time, the probability is less. But if something happens to the executor or if something happens to the witness, then your family members can step in. Your family members have to step in, or you will have to change the living will and add the new witness. Make a new will and add it, because it's not difficult now. It is only a notary who has to sign it. So you can make a new will and add a new witness or the new executor. Generally, executors and witnesses have to be from family so that they are aware. Why it is made is because so that there should not be a fight. One brother says, no, you go ahead. Other brother says, no. It's 1 crore. So then that is the time this living will comes useful, and the family members are aware. Executor is aware that this is what is the situation and giving the physician at the right time. But if the executor is no more there before the person, then you change this.
If a patient is conscious, he has a right to say that stop my treatment.
No,
Conscious patient.
no. Conscious patient, no. You cannot. So that you mean to say when a patient is alive and he says that
I don't want a further treatment.
so that is his wish. So then that living will doesn't come.
Yeah.
So that's a
But
different
it
thing.
It's a normal.
That's a new thing. So when he says, again, now that is a question, like he is alive and he says, I do not want to be kept on my ventilator or like, so he can say that. Yes, he can say that. But then the living will is something which the living will talks when the patient is not here.
When in such a case, when he is alive, take the decision. He has to give a declaration and doctor accepts it.
Yes. It is because he can sign and he can talk. But when living will, it's the will who talks, not the person. Something like that.
In this case, suppose having known the experiences of the near and dear ones or known ill and hearty right now today, but tomorrow he may foresee that similar situation could happen to him. Right now, can I not make a will like this?
Absolutely.
I can.
Absolutely. In fact, living will should be made by everybody. That's what I said the first thing. Living will doesn't have to be done by only by seniors. It's not that. It should be made by everyone, because you accidents or you can be on a life support and unfortunate things can happen to anybody anytime. So wills and living wills should be made irrespective of the age. The people associated with age.
And it can be changed any number of times.
You can. Till the time you are well and hearty. Yes. Yes.
Madam, approximate government fees of that.
Uh,
It's well.
there are no government fees.
Court fees will be only the
Court fees are the bare minimum ones, whatever are.
court fees.
Notary one, and if notary and the charges.
Court fees.
Court fee. That's it.
No
Okay.
other,
Professional fees.
other than that, no other.
Notary is mandatory.
उसमें बहुत competition है.
Notarizing is mandatory.
Notarizing is mandatory.
Or
After
notarizing or registration.
registration is not required, only notarization or gazette officer. Earlier it was not notarization. Earlier it was countersigned by the JHC. That
And
is,
if
but now it is.
you can register it also.
You can, but it is not needed. I mean, the 2023 says notary is good enough. So it
और
does.
आप ही बोल रहे हो कि अगर बदलना है 10 बार तो फिर registration
I mean, now
क्या बदलना है?
what happens?
Ventilator
Normal
one-
अभी मत करो, तभी-
No, normally it's also there is no need for the registration. But people are inclined to do the registration because they feel that it will give
Weightage.
more weightage.
Weightage.
Right?
People are
That
obsessed
is
with
why,
the fact that it is even
that is
bill.
the thing.
Even
And there
with a
are
bill.
no fees for that registration, I think.
Of course there are fees. Of course there are fees.
For normal bill,
No. Of course there are fees. Fees are always there. But the
but very
question.
less. I mean, it is not that because of fee, people won't register.
No.
They find
See,
it
people only
very
feel
there.
it's a psychological thing. Even for will, there is no need for registration. There is no format, but people do register it because they feel the registration government se hua hai. That is going to be my last will. So people do register. then even notarization is good enough, but people register. Living will, they have given a guideline that you need not register it, but I'm sure people are going to register it. Because now we will, as I said, we will also learn. It's just happened in Feb 2023 that they have given a notification and amendment. So this is my first lecture after the amendment, where all this while my lecture was on 18th, the guidelines, which used to be so difficult that there would be questions, ma'am, itna tough hai, kahan judicial magistrate, kaun sa judge, which court, those would be the questions. Yeah, and that would be so difficult. So now let's see what happens after 2023 Feb. There have been, now it is easier, but there will be people who will be registering also, as you rightly said.
Is it happening practically? Because
Yes.
I had not heard about it before.
There are no awareness programs. There are awareness programs happening, which we do because people are really not aware of.
ये चालू हुआ है तो हम हमारे क्लाइंट को बोल सकते
No,
Yes,
exactly.
you. That is yours to
The
always.
purpose of this session was that.
Ah,
awareness.
Which guidelines are referring to? Which
Guidelines pertaining to amendment, living wills. Living wills amendment as per 2023. So
it's
those-
available in public domain?
yes,
Yes.
you can check it out. You can check it out.
I think the will and the living can be combined with it.
Absolutely, absolutely. Because wills are only pertaining to properties and the distribution, whereas living will is only pertaining to medical
Can be
actions.
combined.
It can be. People do it separately. People have the living wills and the properties.
Does it make it separate or can it be combined?
Because
Can
the
be combined.
agendas are different, right? Because for the will is executed after the death, and living will is executed when you are alive. So it is different. So both have to be done, and both should be notarized. So you can even register it, or you can also notarize it. Registration happens in your BMC office, whichever is your jurisdiction. Yeah, you can register it anywhere.
Show the register property.
Yes, same place, same place.
So the registrar value.
In case of ordinary will,
Yes.
is it mandatory to get it notarized or?
As I said, it is not really mandatory. It is not, but it is better to get it notarized or registered because then it becomes your final last will.
Suppose I got it registered today.
Yeah.
One of the witness, I'm not witness,
Yes.
one of the witness expires prior to me.
Okay.
Then what happens?
You will have to change it. You will have to maybe add because it has been, but for the witness doesn't have to be, see, the problem why you need a witness is in case a will is challenged. The only need of a witness is people are signing as a witness only for the fact that this person has signed in my presence. That's the only thing. So if you think that this will can be challenged, then it is better that you have witnesses who are younger to you. That is the logic. Again, that logic also is not a correct logic, but whatever it is, that's the logic. So if the witness dies, it is better to have changed it. Yes.
is it necessary to change?
It is not. It is not. Unless, as I said,
Witness has signed at that point.
yeah,
Witness need not be alive.
if it is challenged, if the will is challenged, who goes to High Court to examine it? Who is going to examine the witness? So if that happens, now the probability is always there. One witness is there, second witness is there. He died on so and so day, but he was present. The notary certificate is there. So it is good enough. It is not compulsory. But if it is possible, then change it. That's the only thing. Because what if both the witnesses die? By the time the will is challenged, both the witnesses die. What do
It
you
may
do?
not be on the stamp papers.
No. Now again, that is also should. There is nothing as should be alive. It is better that he's alive because otherwise, how are you going to be executed? Who will execute it? That is why executors, yeah, generally they have a younger executor, presuming that he'll outlive him. Executor has to be there. And how are you going to do it? Then you again have to change it. That's what I was about to say. You can always have a counter thing. You can have two executors. Yeah.
What is the value of a notary? We can get a notary done for 100 rupees. Purpose behind that. What is the?
So now,
We have the value.
see,
Once it is certified by notary, of course you should pay.
no, you're right. You're absolutely right. See, the fear factor that you got, these are the things which are going to come up after 2023 amendment. as you rightly said, the questions that have been asked to me is, why is that 20 years of experience reduced to 5 years of experience? It's too less. Any doctors in 5 years will agree to it. That is one part. Second is that notary, if it's a notary, then any notary will do it because people have bad experiences of notary. So these are things. But now when the laws are made, they do not consider these, right? They consider that notaries are genuine notary. You will be going to a genuine notary. So now the bottom line is go to a genuine notary who will notarize it. Yeah, because all are professionals, sir.
Answer your question, please have a register and they take their photograph.
No, so-
They take your photograph and.
So I was about to come.
They have that number
So,
also.
yeah. So then if you genuinely want to,
So
so you can verify it. When you ask me a question, how you can identify a genuine notary? The answer is there's a number. Go Google, check it out whether he's there in the list. And if his number is there, it matches with his name and all, he's a genuine. Yes. Wait, that's what I mean. The registration number you can check.
The document number. Sign.
Yeah, of course. They have a register. There will be so many things.
Please.
Yes.
Yeah.
Yeah. Home visit. Absolutely. And it's actually, it's not easy also. I mean, people, there have been a lot of cases we have heard, but the notary also who has been expelled can be, you can check it out. It's not that difficult.
Question is, why should a living will not be done?
What reason?
Huh.
Give just drop one answer, one question.
Yes.
One answer. Why it should not be done?
It should not be done.
Why it should not be done?
So,
Or I will give you 5 answers, but be correct, think correctly. I don't talk nonsense.
no. See, basically, I feel that it should be done. So now when you're saying why it should not be done, you can help me out as to what is your fear factor. The only reason maybe you might feel is they will not be given proper treatment. That is the only fear that people have come up to me saying, what if I'm not even treated? If that is your fear,
It is not going to happen.
it's not going to happen.
Nothing wrong.
Hmm.
But let it be opened up for the open forum discussion.
Hmm.
In what situation I should not get into this again. 99 reasons to do that. Is there any one reason I should not do?
So one reason is that you will still have 1% chance of living and somebody else decides about your death. If that is what you feel, that I had 1% chance of living and these people are the ones who decided that I should die, only for that purpose you may not want to do it. That 1% chance.
Or you want to travel?
See,
Yes,
these are
yes.
the
No, these are thoughts. These are
we all
thoughts.
have to learn.
No,
Sir,
these are thoughts.
we
Absolutely.
all have to learn from each other.
Absolutely.
Maybe my ideas are absolutely okay, but that
No, it's not absent.
it's okay.
हाँ, बोलिए.
I want to tell you, my father died. Okay? So before his death of say 10 years, some 20 pillars or 20 ideas were given. My mother said, my brother, my sister, his own brothers, many people. He kept on saying yes and no and yes, but he did not. Before that, one time I just happened to ask him, Papa, what is the reason? Why are you not making the will? Why are you keeping the gates open for all the brothers to fight. Very absurd answer. None of you will have that. If I do that, you will all start fighting now instead of you fighting after 5 years of my training. Really, see, you don't have to agree with me.
But I tell you, now that you have taken this topic, I can tell you one case study, which is a fact. Huh? This is a fact. One of my clients, he had 3 sons. What he did was, he made will designating this house, one house. He gave that house to A, B, C. He made 3 wills. He made 3 wills. Each child was told, this house is yours. So each child looked after him. He tells me that I made this so that I am assuring my old age. मेरे मरने के बाद जो लड़ना है लड़ो. Right at this moment, this person is taking care of.
I want to add one more point.
So there are people now. This is the kind extremely dangerous.
See,
Now-
in the same building, I want to add you.
That what if all the wills are on the same day? You never know. This one's an idea comes from clients. You know, they give me such figures.
मैं खुद बना के दूंगा ना,
See?
मैं बना के दूंगा और सब भाइयों को बेवकूफ बनाऊंगा.
This is- This
मेरा
is
बाप
one
होता है.
person, no?
Sorry, my इसको घर दे दिया, मैं क्यों इसका मेंटेनेंस दूं? इसको ये अपना फ्लैट दे दिया, इसको दुकान दे दी, मैं क्यों इसका मेडिकल बिल दूं? इसके लो, इसलिए खाना खिलाएगा तो इसको दो. See, this kind of the absurd thing. No, I'm very sorry to say these statements in front of all this living humans. We are so absurd at our own. So if someone was saying that we share this idea to our client, that you do this, first share to ourselves. Myself, am I willing to do it to what extent I can? And then was my wife no wife? जमाई को दिया है, मेरी डॉटर इन लॉ को दिया, मेरे को नहीं दिया है. The same thing, somebody else will start. Who will start thinking? God,
No, but generally, no, you can see
It
the
is
will is
not,
not necessary that when you make it, you have to declare.
Not
to all.
हमारे advocate police है, हमारे issue.
Now that you have this idea is worth giving. Then suppose you want to donate your organs, that you can also. This is going to be in every house.
Yes. Should you be cautious?
Yes.
Madam,
This is
what I want to say, if whether anybody feels that I have this kind of a problem, then what should I precaution should I? It's not that I should not do it. I should do it. But how do I cover these gaps? How do I cover these gaps so that I don't fall into the ditch?
so what you're talking about is will. What today we are discussing is
Is the
living.
living.
Yes. So will you can always take a professional help and then you have guidance.
Keep
We
on
always
changing.
have, yes, because we design
Keep
a
on
will
changing
as
till
per.
you die.
Exactly. So that is a different aspect altogether. Today, when we are talking about living wills, let us concentrate on this part. So as far as the question is whether you can add your organ donation in the living will, yes, you can.
Yes.
You can, because that can be added also in your will. Okay. Now why? Because again, a subtle difference is, the subtle difference is organ donation happens after your death.
Correct.
That's why organ donation part is added in the will,
Correct.
not in the living will. Living will is only pertaining to what treatment to be given to you when you are alive, not dead, but not in the position to communicate your decision or consent. That is the subtle difference.
And despite doing all this, if a person dies, which is a certain
Yes,
today or tomorrow,
yes,
then in that case, I would like to donate.
absolutely. But that
So
is
it could be possible
then-
not to be part of the living will.
no, I agree. But that is not required. You can add it in your living will. Why not? But you can also add it in your will. What I'm trying to say is living will, yeah, you add it in, but pertaining to your consent as per I'm alive and stop my treatment. Can you say or do my organ donation when I'm alive? No. What will happen after death? And after that, who rules? The will rules. You understand the difference?
But that normal will can be enforced only after probate.
No, not necessary. Not necessary.
Not necessary.
Probate is not necessary. It's property. What he's talking about is, you can add it in your living will also. Also, organ donation can be written in your living will, makes it a little easier because anyways you're in the hospital people are there and you tell them and you do it. What I'm only trying to say is, we even add this organ donation thing in the will also. Even before this living will came into force, we used to do it also in the will. Now that
is not be a part of the, means once you, after expiry only, you can able to donate the.
That's precisely what I'm saying. So you could do it also prior. Now that living will has come, you can add it in the living will because you will say, I'm also in the hospital. Doctors ko pata hi hai, to mera kar do. That is okay. That is convenience sake. That is okay. But not, we could not have done the other part in the first will, right? So this was already there in the first will also. We can do it anything.
Ma'am, if there is a something. So what prevails?
You get a first report, the primary report.
From the
Thereafter, you go to the second stage, your secondary report comes.
if there is a difference.
The second one, the latest one. And then you're against it, you do not, they give you against, you can go to High Court. And the High Court one, the last one prevails, always.
Again, I could get appoint another doctor.
Only two boards and there are 3 doctors.
My question was because collusion can happen.
Definitely, that is the reason you have High Court.
That's a
I think we had done. Yeah.
That's where it was for the person that got very.
Yes.
And you said it, like, victims of the family.
High Court.
They just tell the sheet, that way it was.
So you have to file a writ and you will have to make out a good case as to, along with all the documents pertaining to the medical condition, supporting it with physician's report. And then you just apply it to the High Court and pray to them that this is what you would have prayed to the doctors. The same thing, it's just like an application that you file to the High Court. And if High Court then appoints doctors, they have a panel, they check your doctors and they check your patient and finally they give a verdict.
Just to be
Like a petition.
The doctor's report is only one doctor's report is that you can file.
No, there is no doctor's report. You file a writ because here the doctors will not touch your patient till the time the permission is given by the High Court. So you are making an application to the High Court that this case should be considered as a fit case for mercy killing. Then they will send it back to the hospital and the process will start. The 3 doctors, the first primary, that whole thing will start. Doctors, the High Court is not going to direct you and say that, okay, go. No, they will say you go back. They will give you permission for the 3 doctors to have a primary. Yes.
In that case, the 3 doctors will decide that no, the time has still not arrived medically to, allow the mercy line. In that case, you will be compelled to do the medical treatment.
You continue.
You cannot stop.
You cannot stop.
Okay.
Okay, thank you very much. I mean, there is another speaker waiting, so yeah.
Of this
Yes. Feb 2023.
There was waiting period should not be more than may not be this 4 days.
We
What is 6 months? Waiting periods.
waiting period for what you're saying? Are we shifting? Interesting sessions. Interesting sessions. Yeah. You can go ahead.
Yeah, out of syllabus.
Sorry. Thank you very much.
फॉर्मेट हो सकता है ऐसा जो
I can.
yeah,
I was about to read, but I think we are short of time. But thank you, ma'am, for explaining.
Can circulate.
Thank you, ma'am, for explaining the concept of living wills, which is, I think, new for many of us here. To propose a formal vote of thanks, I would like to call C. Vijita Jaiswalji, our deputy convener. Ma'am.
Thank you, Purvi. And Advocate Meera has been really, actually, she's opened our minds, I think. And we've got quite a few ideas which we could share and discuss. And to propose a warm vote of thanks, a very quick round of applause.